This time. Good morning, everyone. All right, for the virtual introduction, I could probably turn on my camera too. Hello. All right, good morning. All participants attending the meeting virtually are asked to keep their microphones on mute throughout the meeting. Commissioners, division staff, respondents, and attorneys participating by camera should remember to unmute themselves before speaking. Please state your name before speaking to ensure a clear and accurate record for both the recording and the preparation of meeting minutes. Speak one at a time and allow patience when waiting for responses, giving participants time to unmute their microphones or account for possible audio delays. Members of the public will be allowed to participate during the agenda items regarding public comment at the beginning of the commission meeting and before the meeting ends. Anyone participating by phone who would like to provide public comment should press *5 to raise their hand and be recognized by hosting staff, or press *6 to unmute and state your name. Participants attending by video may use the raise hand feature to be recognized by hosting staff or unmute themselves and state their name before speaking. All questions, issues, or concerns arising during the meeting should be directed via email to the Commission Coordinator, Maria Gallo. The Coordinator's contact information is provided in the meeting agenda. The agenda, along with all supporting documents, are available on the Division's website. If the meeting goes into closed session, all members of the public and division staff not involved with the agenda item will be placed in a virtual lobby. After closed session has ended, participants placed in the virtual lobby will be brought back into the meeting to hear and/or view the commission make a decision. To receive CE credits, your camera must remain on throughout the meeting, and you must give the meeting your full attention. Once the meeting adjourns, CE certificates will be emailed within 5 business days. If you have any questions, please contact Barry Chappell in the appraisal section. Please note the Teams chat feature is intended for staff use only. Thank you.
Okay, thank you, Amy. President O'Brien. Hello?
Hold on, another technical difficulty.
Okay.
Can you hear me now?
Yes. Yes.
So I'm talking.
You're talking through here.
Gotcha. Okay.
We're listening to them through that one.
All right. Okay, we're gonna restart this then. This is the time and place for the quarterly meeting of the Nevada Commission of Appraisers of Real Estate. This meeting is scheduled between January 13th and January 15th of this year. We'll start with introductions. I am Tim O'Brien. I am the president of the Appraisal Commission. I have been appraising almost 30 years, and I work in a lot of rural counties here in Northern Nevada. And that's residential only. So I'll turn it over.
Commissioner Morris, I have been appraising for about a decade, and I also cover most of the rural areas in Northern Nevada, as well as mostly residential as well as commercial.
Commissioner Kruger, you want to take it around down there in Vegas? You starting?
Sure. Good morning. My name is Scott Kruger. I'm a certified general appraiser and a designated member of the Appraisal Institute. Been appraising for about 37 years with experience in a wide range of primarily commercial properties.
I'm Commissioner Lowe. I am in the Las Vegas area, residential, been appraising about 18 years, the last 10 here in Las Vegas. Also a member of the Appraisal Institute.
Do you want to introduce the staff present today?
Good morning, Commissioners. President O'Brien, Sharad Chandra, Administrator for the Real Estate Division. We've got Deputy Administrator Charvez Foger down here. Also, Rebecca Bruce, who's our Chief of Compliance. Barry Chappell, our Appraisal Program Officer. And you all know James Silva up there, Investigator Silva. From the AG's office, we've got Phil Sue, and Commission Counsel is Todd Weiss. I think I've got it. And administration section, we got the most important folks in the room. Chris Bates and Maria Gallo, and also Amy virtually. Thank you, Commissioners.
Is anyone on the meeting virtually want to introduce themselves?
Uh-oh.
Sorry, I've got to play a lot of back and forth with the speaker.
We're good. All right. Did Vegas hear that last point? We are kind of working with duct tape and everything to hold it together here, but does anyone virtually want to introduce themselves?
Anybody virtually that needs introductions? No.
Thank you. All right. So our first matter of business, and we do apologize. We are moving with 15 fingers and 20 toes, it seemed right now, to get the tech to work. But public comment is our next section. Members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter. No comments may be made regarding a matter that is or may be the subject of a formal complaint before the commission. Comment may not be limited based on viewpoint. Persons who desire to submit written testimony should submit it to the commission coordinator. Anyone participating over the phone that wishes to provide public comment should press *5 on your phone to raise your hand, and hosting staff will recognize that you would like to give public comment. Or you can press *6 to unmute yourself and state your name. If you're attending by video, click on the raise hand emoji to indicate that you would like to give public comment, and hosting staff will recognize you, or you can unmute yourself and state your name. Public comment may be limited to 3 minutes per person at the discretion of the president. So we have no one in Carson City for public comment. I'll turn it over to Vegas for any public comment.
Anybody wishing to go to?
Dugan.
Hi, my name's Scott Dugan. I'm a certified general appraiser. I've been appraising in Vegas since 1969. I sent this letter to Marie Gallo. It's based on the approval CE changes for the real estate salesperson, brokers, managers, etc. LCB file number R060-20 and following similar reasoning. Reducing requirements for CE should also be available for licensed or certified appraisers. Appraisers of all licensed statute, licensed residential, certified residential, or certified general who have been licensed in Nevada in good standing for 30 years or more may apply for an exemption to complete a reduced number of CE credits required for renewal. 15 hours as follows: 7 hours of use map update, additional 8 hours of approved CE courses. Aside from the reduced CE requirements for those with 30 years or more licensure with the state of Nevada, and to further encourage volunteer activity by licensees, participation in the following activities would also count towards the CE requirements and be awarded CE credits as noted below. Members of the county or state board of equalization would be granted a maximum of 6 hours each 2-year license period, 3 hours for each current year of service during the renewal period. Members of the appraisal review committee would be awarded a maximum of 6 hours each 2-year license period, 3 hours for each current year of service during the renewal period. Service of the appraisal commission would be awarded a maximum of 6 hours each 2 years license period, 3 hours for each current year of service during the renewal period. Service related to the appraisal foundation, members of the AF, ASC, ASB, etc., would be awarded a maximum of 6 hours each 2-year license period, 3 hours for each current year of service during the renewal period. That's it. And I think I sent it to everybody. Everybody got it. So just
Part of
something
the
I'd
record.
like you guys to think about. Thank you.
Thank you, sir.
You want this letter too? Leave that?
No, yeah, they have it. They have a copy.
They all have it. Okay, great. Thank you, ladies and gentlemen.
All right, thank you, sir. We need 5 minutes here to get, okay, hold on one second, everybody.
As long as you don't need to see.
All right, Las Vegas, sorry about that. We are going to work through the tech items here. We have two different platforms we're using, both the iPad, and then Mr. Silva is trying to square up the other meeting stuff, but that's a struggle right now. So I can see Commissioner Kruger if he fools around, but I just can't talk to him. Thumbs up.
Can you guys hear us now?
Yeah.
All right. Kruger, that's thumbs up. Perfect. All right.
Yeah.
So number 3 on our agenda for possible action, discussion and
Apologies.
decision. Respondents
Hold on.
to seek clarification on the duration of the
I have-
revocation. This is case Enred versus Bradley W. Korn for possible action, case number,
No, Brian.
I guess,
We have
I-
to take turns between, hang on, we have to take turns between muting and unmuting ourselves, and then we can't hear you while we're speaking. So yeah, if you wave your hand, we will stop talking and turn off. So we got you.
Wonderful. We need to complete public comment with virtual. I do have somebody virtually who is interested in giving public comment. Go ahead, Brianna.
Hi, good morning. My name is Brenna Nichols. I'm a senior management analyst at the City of Reno. I'm here today to inform the Commission that we'll be opening our application for inclusion on the City of Reno's Certified General Appraiser list in the coming weeks. And once that's opened, the application period will be open for 3 weeks. I will be sending the application to your staff to be disseminated through your official channels, but I just wanted to provide this group with advance notice. And that is it.
thank you very much.
Thank you.
So now just confirming anyone else virtually wanting to address the commission via public comment.
No, there is no one else who is interested in giving public comment at this time.
Okay, perfect. Thank you. All right. So I'm going to restate number 3 here just for a minute. That's where we're at. For possible action, discussion, and decision regarding respondents' petition to seek clarification on the duration of the revocation of license. This is case Enred versus Bradley W. Korn for possible action, case number 2021-512, license number A0005827-CR.
Good morning, Commissioners. Making my appearances for the record, Phil Sue, with the Attorney General's office that I represent the division in this matter. I believe Mr. Korn might be appearing remotely, possibly. I don't know if Amy could canvass the room with that.
I had seen him earlier. I am not seeing him at this time. No.
That being said, if you want, I could give some preparatory remarks regarding the situation and or I guess I can defer to commission counsel whether that makes sense.
This is Senior Deck Todd
Hold on.
Weiss. I would rather him be here for the entire thing if we're gonna do that, so maybe go to a next agenda item, see if he shows up.
I do see a raised hand.
I'm here, guys.
Oh.
Yeah, I'm on the call.
Great. Mr. Corn, if you could just state your name for the record so that they know that you're actually here.
Yeah, my name is Brad Korn.
Great. Okay, so this is regarding the commission order that was signed, I believe it was about October, November 2024, came to a settlement that the division had reached with Mr. Korn. And within that settlement agreement, he had agreed, among other terms, to it was actually to surrender his license. It was characterized in the settlement draft that I wrote as a revocation, but typically revocation only happens if you go through an entire case. And it's more of a penalty than a situation like here where it should more properly be classified as a voluntary surrender. And so the position that the division has today is, well, first of all, background, he owed about $19,000 in fines from that order. I understand from speaking to the division that that amount has been paid in full. And so he is compliant with the other terms of the order. That's the first part. And the second part is that since it's probably better to classify it as a voluntary surrender of his license rather than a revocation, the division's request that we amend the terms of that settlement order to reflect a voluntary surrender rather than a revocation. You can include additional terms if you wish, as far as if he wants to reapply for appraiser license with Nevada, which could because he doesn't have one right now, then he has to come back before you all for to explain the circumstances. Part of the reason why he surrendered his license from that settlement agreement was because he didn't intend to practice appraisal in Nevada anymore. And so this was negotiated not only with him, but at the outset was with an attorney as well that he had retained, Rick Lower. So that settlement agreement was vetted not only by him, but also by his attorney and by me. And unfortunately, none of us caught that the language said revocation instead of voluntary surrender. But even with voluntary surrender, the commission can still place a time frame for how long that surrender would be in effect. My recommendation, though, under the circumstances where he's already paid the fine in full, and he's been compliant with the terms, and my understanding is he's not even trying to reapply for a license at this time. He just needs to understand what the time frame is for that revocation / voluntary surrender, so he can apply for a license elsewhere. So if you want to place a time frame on it, that's fine. But perhaps state as a voluntary surrender, no time frame, and that would allow him to, if he wants to, or that he even satisfied the. If you put it for a year, for example, then that would be a voluntary surrender, and he can't reapply for a year. That year's already passed, so you could do that and make that time frame moot, but just to give it a time frame certain. You could do that as well. But if we could change the stipulation to read voluntary surrender rather than revocation, I think that would accomplish the main goal. And I'm free to answer any questions that any of you might have.
Yeah, so to clarify, this is not just to seek clarification on what the order was, but it's actually to amend
Yeah,
the order.
That's probably true. That would occur whether or not it was going to continue to stay as a revocation or not. He was looking for a time frame, and I had researched the case law regarding revocations under another statute that doesn't apply to our to this commission. It's under 622A point or O, I believe it to be. 10 years is the typical time frame for it's going to be one year through 10 years. The time frame of revocation can be for a professional licensing board in Nevada. Now that statute doesn't apply to the Commission of Real Estate Appraisers in Nevada, but it does provide guidance for what the time frame should be. That being said, in this instance, we're not necessarily saying, or our recommendation is not to stick with that revocation language, but instead to call it a voluntary surrender. And if you want to put in a time frame, maybe put in a year, so that that period of time that he was unable to reapply, has already passed. He's already complied with the other term of the settlement stipulation, which was to pay his fine, which he did in full last year. I believe it was November of 2024, actually. So, and then he'd be able to go forth and try to get his license for that other role. Oh, and the additional term would be if he wants to I would also recommend you add an additional term. If he wants to reapply for his license, then he should come before the commission for approval to explain his circumstances before we proceed with that. So it'd be those additional terms. That it change into a voluntary surrender, timeframe certain, make it a year, and have him come back to the commission if he wants to reapply for a license.
Just a quick follow-up question, really kind of a legal question. I went into NRS, and I don't know if this applies or if it's relevant to this case, but 645C.460, number 3 states that if a certificate, license, or registration card is revoked by the commission, another certificate, license, or registration card must not be issued to the same appraiser or intern for at least 1 year after the date of revocation. So there's kind of precedence there, I think, for 1 year, or at any time thereafter, except in the sole discretion of the administrator. And then only if the appraiser or intern satisfies all the requirements of an original certificate, license, or registration card. So that last part, would that mean that they would need to start over and meet the requirements to become certified?
This is Senior DAG, Todd Weiss. Commissioner, if I understand what Mr. Sue is saying is that he wants to change it from what was previously a revocation to a voluntary surrender, so it would not have that same caveat that's in the NRS. Am I getting that right?
You are, but I think what the statute that Commissioner Kruger pointed to is excellent as far as providing guidance.
And I think he's also recommending year anyway, except you're saying year is already passed, so
Correct.
it's.
It'd be in compliance with the statute, and it also provides a date certain, which is what we were seeking in the first place.
So the only thing I would recommend is whatever's in the order, we're going to make very clear that where the year started. Because normally these things say year from the date, the order is signed. So we're backdating that year to make sure that's clear.
That's right. That's right. All the language in the stipulation points to the effective date of the order. So that year would also be backdated back to the effective date of the order. It would not be effective as this.
Which was October 9th of 2024.
Right.
So I agree with Commissioner Kruger that I had that NRS section up while we were talking about it, because I remembered that as well too. One of the things in that same statute is grounds for disciplinary action against a certified or licensed appraiser. And that then goes to 1E, the suspension, revocation, or voluntary surrender in lieu of other discipline of a registration card, certificate, license, or permit. So it seems to me that we have to give it the time frame because it shouldn't be in perpetuity forever. But at the same point, I think having to come back in front of the commission because we've heard that he does not intend to appraise here anymore. If that changes, we would need to understand those changes. So I'm open to a year with any time any time that he wants to or attempts to reactivate or get a new license, that he would have to come to the commission before that proceeds. Any other comments?
Yeah, this is Brad Korn. May I comment?
Yes, sir.
Yes, go ahead.
So just to echo what Mr. Sue was saying is I do not have any intention of going back to appraising, but in my new career as a financial planner, I'm trying to earn a certified financial planning designation, a CFP designation. And when I started studying for the program, I got to a point where if I had a previous revocation of a license, that I was unable to earn a CFP designation. And that's what prompted all of this, is that if we can whether it's a revocation or a voluntary surrender, which it was a voluntary surrender, as soon as that time frame is up, then I'm eligible to qualify to earn a CFP designation. So that's what all this is about. And so I agree with y'all. If we could change the language to a voluntary surrender, 1 year time frame is fine with me. That time has already passed. And then I'll be able to proceed with kind of my new career.
All right, so thank you, Mr. Gordon. I think at this point, if we do not have any other questions, I will entertain a motion.
President O'Brien, this is Commissioner Kruger. I'll go ahead and attempt this. In the matter of NRED versus Bradley Korn, case number 2021-512, license number A.0005828. I move that we amend the original order dated October 9th, 2024, so that as part of the terms of the proposed settlement, item number 1 is revised to reflect that respondents license number A.0005827-CR is voluntarily surrendered, and that would be for a period of 1 year commencing on the date of the original order, and that the respondent would be able to reapply for a license at any time after that period by coming for this commission. Does that cover it?
If I may, Phil Sue for record, just to clear. So he would apply with, and the application for license would be contingent upon the commission at its next regularly scheduled meeting, something along those lines.
Okay, so do I need to, that last part, we just add that comment and we're good.
There you go. Thank you.
That's my motion, President O'Brien.
All right, do I have a second? Come on, you new commissioners. I'm going to start pulling teeth here.
I will second it.
Oh, we had Commissioner Lowe second.
Any further discussion?
Okay.
All in favor of the proposed motion, say aye. Aye. All right, that is so moved. Thank you, Mr. Gordon.
You're welcome, and thank you. Do you all need anything else from me at this
Our
point?
next file is under number 4. It is NRED versus Glenn J. Howard, case number 2024-645, license number A0007090 -res.
I'm sorry, President O'Brien, can you please call 4A and just stipulate for the record that he received a continuance?
Okay, sorry about that. So for number 4, our first case listed is NRED versus Braden C. Critchlow for possible action, case number 2023-449, license number A.0003929-CR. It is my understanding in this case that Mr. Critchlow has received a, what do we call it?
Continuance.
Extension to a future commission meeting.
Thank you.
Any comment? Oh, sorry, go ahead. Sorry, go ahead.
No, you may continue. Thank you.
Now, we're going to go back to 4B, NRED versus Glenn J. Howard for possible action, case number 2024-645, license number A0007090.RES.
Thank you very much, Commissioner. This is again Phil Sue on behalf of the division. I don't know if Mr. Howard is present either in the virtual room or here in this room. I don't know if that's something you can check, Amy.
Yeah, I am checking. I do not see Mr. Howard. If you are attending virtually, Mr. Howard, please raise your hand. I don't show any recognition.
Thank you, Amy.
Is there any council representation here on behalf of Mr. Howard?
Yeah, yes. And just so commissioners are aware, the division filed a notice of default on January 5th of 2026. That was mailed out, was a certified mail to Mr. Howard's addresses of record. My understanding too, and we can confirm that with Maria Gallo, who will be testifying in this matter as to costs and mailing. So we may need to put her under oath at some point. But my understanding is that that notice of default was also received by one of his addresses. But we're under these circumstances, we're going to be proceeding as a default on this underlying case. In broad strokes, this is a matter where he didn't even provide the underlying work file to the division for investigation as to use PEP violations. And that is the sole allegation of the underlying complaint here. There are additional allegations, but by not providing the work file, we don't even reach those. The complaint sets forth that Mr. Howard has already had a very voluminous disciplinary record before this commission, has come before you all in pretty recent history with other issues. In fact, I believe that as of the date of the filing of the complaint, if his license was in suspended status. So a little bit of the procedural history on this. The matter of this file was, the complaint was filed for the October meeting. The October meeting was canceled. And so that's why we brought the matter here now today. So in essence, Mr. Howard has had about four plus months to respond to the complaint and failed to do so. So that being the situation, I'd like to call Maria Gallo to testify regarding service of the complaint upon Mr. Howard, and then we will proceed with a prove up for the underlying discipline on the complaint.
Sounds good. Let's proceed.
If I may, I think we would first need to have somebody swear Ms. Gallo in for her testimony.
I don't know that we've run across this. Do commissioners swear people in, or what's our normal process here?
Oh, I'll defer to Commission Counsel on that.
This is Steve Beck, Todd Weiss. Mr. Chair, the swearing in is usually done by the chair. Do you need the language to do that?
I need it.
Man, I can't actually read the language at one time.
Rosalie did it last time.
Yeah. Okay.
I mean, I'm happy to. I'm happy
yeah,
to
if you
swear.
could, that probably.
Okay, Ms. Gallo, can you please raise your right hand? Oh.
Sorry.
Got my. Ms. Gallo, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good morning, Ms. Gallo. Could you just state your name one more time?
Maria Gallo, Mission Coordinator.
What is your and so how long have you been working as a commissioner?
3 years.
And as part of your tasks as mission coordinator, you also handle the mailings that come with cases before the Commission of Real Estate Appraisers.
Yes.
So is it correct to state that you also handle the mailings for case number 2024-645 NRED versus Glenn Howard?
Yes.
did you can you confirm that you had mailed out the complaint, notice of complaint, documents and the Bates stamped documents in this matter?
Yes.
When did that occur?
Sorry, you're asking me about the original one.
I believe it might have been on September 30th, 2025. The Staghorn, 20 Staghorn Street and 1429 Minuet Street addresses, is that correct?
Yes.
Those letters were returned to the division as undeliverable, but indicated a new forwarding address for the respondent, 3702 Neblina Drive.
Yes.
And so on December 5th of 2025, did you send a new notice of hearing for this case, for this particular hearing date to the respondent at that Neblina Drive address?
Yes.
And did that come back undeliverable, or did you get a confirmation of delivery?
I did not get any of the above. For my case tracking, I checked the United States Postal Service website by putting in the tracking number. And per that website on 12/8/25, it was, the post office has said the delivery was refused.
Just to confirm, the three addresses that you sent these notices to were either Mr. Howard's addresses of record with the division or addresses that indicated in his forwarding notices for those prior addresses, correct?
Correct.
And that most recent delivery was refused. That's what you saw on the post office website.
Yes.
Was this also the Neblina address, also the address that you sent the notice of default to?
Yes.
Did you send the notice of default to the other addresses as well?
Yes.
What was the status of the notice of defaults?
The one at Staghorn was returned to sender, and it had the Neblina yellow label as the forwarding address. And then the one from Neblina, I received the green card yesterday, and it was signed for. Can't quite make out the signature, but it was signed for.
Okay. At this time, I would like to move the commission for admission of all the documents, the notice of the complaint, the notice of complaint, the notice of default, as well as the Bates stamp documents in this matter. I believe pages 1 through 72, and as well the notice of default that was sent to the three addresses as well, and all the confirming slips of paper from the post office. I just need the commission's approval on the documents.
Yes, go ahead, please.
Thank you very much. And with that, I believe that I've provided the information necessary for the commission to make its determination regarding default.
Sorry, in the interest of education, can you read the complaint?
Oh, of course. Okay, thank you.
Real quick for housekeeping. So in the meeting packet, there is, the last item is do not open until XX. Is that the file for this? Do we open that now? Is that where?
Yes,
appropriate documents?
Now that they've been admitted as evidence, now I believe you can open.
That's for this case. Yes.
Yes.
Okay.
So what that includes is the complaint that was filed with the division, which with the commission, which I believe you already had a copy of, but also the 72 pages of the underlying investigation that ended when we did not send in his work file.
Okay, thanks.
At this time, I'd like to ask the commission for leave to read the underlying complaint into the record. So for the edification of everybody who's viewing this either here in the room or online, as to the underlying circumstances of this complaint.
Go ahead, Mr. Sue.
Thank you. On or about July 9th of 2024, the division received a complaint alleging the respondent committed misrepresentations, numerous errors, and extraordinary opinions of value in the two appraisal reports prepared October 12th of 2020 and July 9th of 2022 on the same subject property, 9739 Fox State Street, Las Vegas, Nevada, 89141. The division could not commission a standard 3 review of the underlying appraisal performed by the respondent to determine if compliance with the Uniform Standards of Professional Appraisal Practice, USPAP, within the subject court because respondent failed to supply a work file. From 2019 to 2024, respondent had a total of 7 cases on file, including this case. 2019-585, 2019-751, 2020-576, 2020-623, 2021-607, 2021-675, 2024-645. Those are the 7 cases, whereby the respondent proceeded to commission on all previous cases and currently has a suspended license for failure to pay administrative fines in the amount of $25,803.52. Given the numerous prior disciplines and current suspended license, the division determined this matter should be heard by the Nevada Commission of Appraisers of Real Estate. Now moving on to the factual allegations. On or about August 15th of 2024, the division opened its investigation against the respondent, requesting the entire work file and any supporting documentation on or about October 9th of 2024. The respondent failed to respond by the due date. Therefore, on or about January 16th of 2025, the division, as a courtesy, provided an extension to respond by January 31st of 2025. On May 23rd of 2025, the respondent untimely submitted his rebuttal to the division, failed to include his work file and any supporting documentation. On May 23rd of 2025, the division, as a courtesy, provided the respondent with yet another extension to May 30th of 2025 to provide the documentation and work file. As of August 8th of 2025, the division has yet to receive any documents or work file from the respondents. Now the violations of law. First violation. The respondent's actions constitute unprofessional conduct pursuant to NRS 645C.480 for failing to produce his work file and any documents after being requested to do so numerous times by the division as part of its investigation of complaint. So that concludes the reading of the relevant portions of the complaint for the record. At this time, the division submits the complaint as well as the notice of default for the commission's determination as to whether or not to find default on this matter. Thank you.
All right. Last chance in terms of Mr. Howard. Is Mr. Howard present or any counsel? Mr. Howard? All right, Mr. Sue, then you can continue. Anything else you've got?
Nothing else to add. I think at this juncture procedurally, I just need a determination from you all as to whether or not the division, the commission finds default against him, and if so, if the division has proven its factual allegations and legal allegations. If upon that kind of finding, I am prepared to provide disciplinary recommendations, including sworn testimony from Ms. Gallo as far as division costs and fees.
Great. All right, commissioners, discussion on this. Do we believe that that the complaint is in default status right now and looking to move into a new period or a new section of disciplinary action?
Before I unmute, yes, I believe that has been proven.
President O'Brien, this is Commissioner Kruger.
Thanks.
Has been proven.
Commissioner Lowe, I also agree.
So at this point, do we need a formal vote by the commission?
Bill, for record, yeah. The next step would be for you all to make a motion.
So, good. Or Mr. Sue, you got something? Sorry.
Oh, no. You took the words out of my mouth. Thank you.
No worries. So in the matter of NRED versus Glenn J. Howard, license number A.0007090-RES, I move that the complaint is in default and that we move forward to disciplinary action under this default.
I will second that.
All in favor?
Aye.
Right. So Mr. Sue, I think it's back to you now, correct?
Yes, it is. Phil Sue for the record. Yes, thank you very much for that. And the division's recommendation as to discipline is that Mr. Howard's license, which is currently suspended, is now revoked for a period of 10 years. That he has to pay the division a fine of $10,000 for the single violation of the complaint, and that he also has to pay the division its costs and fees for the complaint for which Ms. Gallo is ready to testify. An additional term, that revocation, if he wants to reinstate his license or seek a license with the commission after the 10 years has elapsed, then he needs to come back to the commission for its approval before he can obtain that license.
So one logistical question that I have is, I know that the first or the primary first violation is the appraiser's actions constitute unprofessional conduct pursuant to NRS 645C.480 for failing to produce his work file and any documents being requested. Is there also something that we have to address that he has not provided an updated address to the commission or to NRED? And if so, how is that handled? As a monetary fine or as just something he would have to provide if he came back to try and reinstate the license?
Excellent question. I believe as drafted, this complaint doesn't contemplate that particular violation. So that would perhaps be something that the division could bring forth in a subsequent complaint if it wished to. But we're constrained by the complaint that was filed here. So we really need to focus on the violation we have. Although
Ms. Gallo may have curiosity in terms of that. So, and then to the division staff, does Mr. Howard have any more open cases, or is this it?
If I may interject, Phil Sue for the record. Even if they did have those complaints or an investigation undergoing, until it's a formal complaint filed with you all, it's subject to confidentiality. So they could not necessarily speak to that even.
Maria Gallo,
This, do we have a motion from one of the commissioners? Oh,
I think Ms. Gallo wanted to say something real quick.
Maria Gallo, for the record, President, I just want to answer your question because Mr. Howard was in recently and did pay to renew his license. And in that, you have to fill out a renewal form. On that form, he did list the Nabalina address. So now we have his current address.
perfect. Thank you for clarification there.
If I may add, that
Any
recent, when Ms. Gallo said recent, we mean the same day that the default was filed, January 5th. That was also coincidentally the date that he came into renew his license. So it happened very, very recently. That's for the record.
All right, then I'm going to proffer a motion that, let's see here, 1 second. I get the right screen up here. Sorry, give me 1 second.
Or he does the motion.
Oh, sorry, one more.
So I'm going to offer a motion that, oh, sorry, go ahead.
Sorry, one more interruption. Phil Sue. I think it may be prudent to obtain the fees and costs on the record from Ms. Gallo before we make the motion.
Idea. You go ahead.
Okay, so Maria Gallo, for the record, in the case against NRED versus Glenn Howard, case number 2024-645. The fees and costs in the above case are in the amount of $4,968.59. And those fees are reasonable, necessary, and actual.
Great, thank you. All right. So again, I'm going to make a motion in regards to the case NRED versus Glenn J. Howard, case number 2024-645, license number A.0007090.RES. I'm going to move that the license of Mr. Howard is moved from suspended to revoked, and also that he be assessed fees and fines of $14,968.59. That is the $10,000 fee for the one item of violation, as well as the costs and fees borne by the division.
President O'Brien, I think you need to amend that for the, to add the period of the revocation being 10 years
And the due date of
and the due date of the fees.
All right, so I can do, what is it, you're talking about due date for fees?
Yeah, and the period of the revocation being 10 years.
So before I proffer that, then do we have, what is our typical process for fees and costs? Do we have a default position of 30, 60, 90 days? I think we've been all over the board on it since the years I've been on the commission.
Yeah, Bill Sue, for the record, I believe it's really at the commission's discretion, but if you want to provide a measure of consistency, I think 60 days might be a good compromise.
All right, we're going to try this one more time. In the make a motion for NRED versus Glenn J. Howard, case number 2024-645, license number A0007090-RES. I move that we move the Mr. Howard's license from suspended to revoked, and that we also have fees of $14,968.59. This is a $10,000 fee for the item, the finding of violation law, and the costs of the fees and costs of the division, which are $4,968.59. The revocation shall last 10 years, and the fees due are within 60 days.
For simplicity's sake, I will second that.
Sorry, one more term. If he wants to reapply after the revocation, then he needs to come back for your approval first.
Do you, can I just add that as an amendment, or do I need to restate the whole thing again?
Senior DAG Todd Weiss, yes, Mr. Chair, you can just say so amended, and that's perfectly fine. No need to read the whole thing again.
So, so amended.
And I will re-second.
Thank you.
Commissioners, any other further discussion on this case?
No, sir.
No.
So all in favor of the motion against Mr. Howard, say aye.
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 Thank you very much. I believe that that'll do it for this one. Thank you very much, everybody.
Thank you.
Yep, I have one other question. I'm sorry. In terms of the previous case that we just heard against Mr. Korn, are there any additional fees or costs that division board that have to be passed on?
Phil Stu, for the division, I don't believe so. Any administrative costs at that point are kind of important.
Hi.
Just
All right,
letting,
Sue, I heard you say you did not think there were any fees.
yeah, in fact, I received informal confirmation from division staff that there are no additional on Korn.
All right, it's now 10:05. Let's regroup at 10:15 to go to number 5 on the agenda. And we're going to try to keep getting our system to work here.
Maria, can you unmute? Maria, can you unmute? Maria, can you unmute? Now they can hear me. Oh, they might have muted everything.
Carson City, are you able to hear me?
Oh, we're muted here. I thought.
Yeah. No, we're.
Oh, let's see.
Hi, Carson City.
Can you hear us?
I can hear
Okay,
you, yes.
You. Dang it.
You,
All right.
no,
Hold
still
on while
no.
Keep talking or singing, and we'll try to switch speakers.
I don't know. I've reserved the voice for special occasions, so I think the song is going to have to hold out. But I will keep talking until you say that you're able to hear me. So, hello, Jim. How's the weather up there? Are you cold and snowed in, or you got some nice, clean roads up there? I can tell you there's a little chill in the air down here, but we're not snow covered at all. I see that, Mark, you have your hand up. What do you want to say? You still working on it? No luck at all? I'm going to try muting and unmuting you just to see if that is something that will help. So I'm going to disable your microphone, and then I'm going to allow your microphone. Okay, did that help at all? Still no? Yeah. I'll keep talking though. Anybody else able to listen in? This is great. I've never been a radio host, so I want interjection, but I've never had it. So, can we? No, still nothing. I wish I was able to hear a little bit from Carson City. Any luck up there? Well, I have to say, it's been a lovely day around here. We're hoping that our next session goes very smoothly too. We'll be having the Appraisal Foundation, Peter Fontana, speak or have a discussion regarding the Appraisal Foundation State Harmonization Task Force with a little guest speaker of Mr. Russell. I feel like I'm making commercials here. Yeah. Yeah. Okay, thanks. Yes. No, still can't hear Carson City, but we look forward to the day we can. Any luck there? Let me know if you can hear at all. My commentary has run dry already. Yeah, I would not succeed as a radio host. I think I need a teleprompter or something to start reading the Constitution, the national anthem. I need something. You're blurred out. You're fine. Yes. Hello?
I don't know if that's.
I can hear you. Yes, but still can't hear me, huh? You got the red and the white and the yellow all plugged in wherever they're supposed to be plugged in. And sometimes you got to crisscross them. It's been a while since I've set up AV. No luck. It would be really very good if we could cross some wires and keep trying to check with that. I tell you, My coffee level is low today. I see your lips moving, but I don't hear anything yet. So, um, looks like we had photos taken. Say it again. Cherise. Yes, they're trying to see if they can hear me. So they wanted me to sing, but I'm not. I'm reserving that voice. So we'll keep going. No luck yet, Carson City? Still can hear you.
Right.
Yeah, no.
Turning off the small screen. We're fine.
You're going to
Have
work
to
that
do it.
way? Okay.
Only talk, but not listen. And then we have to turn off our talking and then listen. So that's why we're real bad at letting people speak.
Literally.
Yes, I'll go back to the virtual introduction with the please allow time for delay in speech.
Yeah, and if anybody in the room needs to talk, do that. They're waving their arms up and down, and that works perfect for us because we won't hear them as we're talking over.
Wonderful. That sounds great.
All right, as soon as Commissioner Kruger is ready to go, we can start.
You can.
All right, it's 10:15, so let's get ready for discussion on point 5. Let's see. There it is. Commissioner Kruger, great. All right, our next matter of business is discussion regarding the Appraisal Foundation State Harmonization Task Force. And this is going to be a presentation by Pete. Peter, you know him as Pete, but I'll call him Peter. Peter Fontana, who's the chair of the State Harmonization Task Force. Mr. Fontana, welcome.
Thank you, Mr. President. I appreciate the opportunity to speak in front of the commission today. I'll just give you a little background on the State Harmonization Task Force and what we're doing at the Appraisal Foundation. So just about a year ago, our Board of Trustees stood up a task force to try to assist states with being more in sync with the criteria to become an appraiser. There's a lot of states that have what we consider overlays over and above the criteria the minimum criteria that the foundation puts out in the AQB documents. And as you all know, the foundation is going through a total rewrite of the criteria. Let me just back up just 1 second here and introduce myself. I'm Pete Fontana, and I'm the chair of the Montana Board of Real Estate Appraisers and have been for the last 12 years. I also serve on the Board of Trustees for the Appraisal Foundation and the Board of Directors for the Association of Regulatory Officials, or ARO. I've been in the appraisal business for almost 30 years, and I'm joined today by Scott DiBiasio, which is one of our task force members from the Appraisal Institute, and online I'm joined with John Ruffel, which is also one of our stakeholder task force members with Value Site Consulting, and they'll also be contributing today as well. So I'll continue with the charge of our task force. Our task force, we're examining all the laws, rules, and regulations of every state board to see if there's any overlays over the minimum criteria. And one of the reasons we're doing that is because at the foundation, we're looking at the appraisal business it's really in a state of crisis as far as the number of appraisers in the profession. So there was a study done a year ago, and in 2016 there was 92,000 individually credentialed appraisers in the United States on the registry, and that's not appraisers that held licenses in 5 states. That's unique identified appraisers. In 2025, that number has shrunk to 65,000 from 92,000. And the prediction is by 2030, that number will shrink to about 53,000 appraisers, which is not enough to cover the amount of work necessary to complete the lending appraisal work. And so also the advent of the new appraisal form that Fannie and Freddie are rolling out here right now, it's in the process of being rolled out, the new UAD 3.6. We have been polling appraisers at every conference that we've attended if they are going to continue to be an appraiser with the advent of the new reporting requirement. And we're predicting that we're going to lose another 15% of the appraisers nationwide are just not going to renew their license. And so we're trying to get ahead of that we want this profession to thrive, and we want appraisers to be providing values for collateral loan purposes. And the only way we can do that is if we can make sure that we can visit with state boards to see if they have any unnecessary barriers to entry. And so this is our 19th state we visited, and we wanted to do direct engagement because we think it's better to come and sit down and talk to the boards personally rather than try to do this through presentations at conferences or emails or letters. We think that the best approach to this is direct engagement, so we can be involved with the boards and let you know that we're here to help. We don't have any authority to direct you what to do. We don't have regulatory authority. We are a congressionally authorized agency that is authorized to set standards and qualifications to become an appraiser. And so that's what our charge is here. And one of the statistics that is a little bit troubling for us regarding this new appraisal reporting form, this UAD 3.6, is that the largest software provider for appraisers has around 40,000 members, users, and they only have 22% of their users are using the mobile app that they've had available for 10 years, meaning they're capturing the data on a tablet or a phone. And so they've had that app available for 10 years, and only 22% of the 40,000 appraisers are actually using it. And that means you're assuming that everybody's just going to pick up an iPad in January here and start doing this new UAD 3.6. And I think that's unrealistic. I think a lot of people are just going to retire. So we're in a little bit of a situation where we can ill afford to be losing appraisers at the pace we're losing them at and not replacing them. And we hope that we can, discuss some of the barriers to entry that some states have and see if we can try to turn that around a little bit to make it easier for folks to get into this business. We're not trying to lower the requirements by any means. We are trying to ask states to just comply with the AQB criteria. And the criteria is obviously changing. One of the charges that we asked the Appraisal Qualification Board to do at the Board of Trustees was to take a look at the criteria, like FIREA came around 35 years ago, to take a look at the criteria as if FIREA happened today. What would that look like today? Well, back 35 years ago, you were using Kodak film, you were using clipboards, you were hand delivering reports. So we're asking them to look at the criteria in a more technologically advanced way to say if there's other ways appraisers are using techniques and to get experience and to get their hours in. So that's the charge of the AQB, is to look at that in a more modern way. And so with that, I would like to introduce John Russell, one of my valued team members on the task force. He's in Washington, D.C., and he's going to present via Zoom here. And he's just going to kind of go over some of the overlays that the state of Nevada has that we would hope that you would consider. You're going to have to do something if you're going to adopt the new criteria that the AQB is putting out. And so once you do that and you open your rules up, or you have to have a statute rewrite, and we just want you to be aware of some of the challenges that exist currently in your statutes that could be corrected, because once the new AQB criteria is adopted, then most states are going to have to notice that somewhere in their rule or their statute. And so when you're doing that, we would hope that you would take a look at that. And so I'm going to turn it over to John Russell for a little bit of a review of your work, of your statutes and rules.
Yeah, thank you, Pete. And I'm just going to look for a nod of heads. I can see you all on camera. You can all hear me. Yes, no, maybe so. I've got heads. Yeah, all right. We got the gremlins worked out. Well, again, thanks everybody this morning for making time for us. As Pete mentioned, my name is John Russell. Currently, I run a consulting practice called Value Site Consulting, working with appraisers and appraisal organizations. I'm a past member of the Board of Trustees of the Appraisal Foundation. I've been operating in this space for over 16 years. Focused primarily on appraisal and valuation policy at a federal and state level. As Pete talked about, when we've been coming and having these conversations, our focus has been on overlays. I think it's helpful to define what we see as overlays, and then really differentiating between problematic versus non-problematic overlays. So an overlay, quite simply, is anything that exceeds what is required under the current real property appraiser qualification criteria. As you know, we just went into effect with the 2026 criteria at the turn of the new year. So anywhere that there's something that a state is doing that is above and beyond what's written in those criteria, we view those as an overlay. Now, some non-problematic are kind of non-issues. A great example is if you have a requirement for a high school diploma as part of pre-licensure. Technically, that's an overlay because that's not a requirement under the criteria, but that's not something we really look at and go, okay, well, what are we going to do about that? Or is that problematic or a barrier to entry that's really steep for potential licensees? We wouldn't look at that and really lose too much sleep. And part of the conversation too, before I address really specifically the one major overlay in Nevada, part of the reason we want to come in and have these conversations and identify them is really to get you all as a board thinking about, do these overlays continue to make sense in 2026? Do they continue to benefit users of appraisal services and those who rely on the services of appraisers in your state in a way where materially it's improved over what would happen under just the base criteria? Or is it working to forestall entry into the profession? Really, it's a cost-benefit analysis, right? Between what is this getting us versus what is it costing us? So in terms of overlays, I think no surprise, hopefully, to all of you in the room, the major overlay in Nevada has to do with experience, specifically hours of experience, as well as the minimum time frame for acquisition. As you already know, in Nevada, you need 2,400 hours of experience, no fewer than 2 years for a licensed residential credential, 2,500 hours of experience, with 500 of that being complex transaction, over no fewer than 2 years for certified residential. And my mind is now blanked on certified general. Come on, Brayton. There we go. 3,600 hours, 1,500 hours being non-residential for certified general. All three of those totals exceeding the minimum established in the real property appraiser qualification criteria, and the time frames for acquiring that also significantly longer than what the AQB allows for those different license levels. So that's really the one main overlay that you have. Now, the other one I'm going to flag it, but then I'm actually going to applaud it because I think it makes a lot of sense in terms of getting people to really understand the environment they operate in. Because you also require your licensees pre-licensure to attend 6 hours of meetings just like this. And when we talk about the moments in which an individual deals with you all as a board, it tends to either be at the point at which the license or certification is acquired, or as you just talked about at the beginning of this meeting today, when there is an issue that comes up when a complaint has been filed and they are brought before you as a board for some kind of reprimand or sanction or any other action taken against them. So I actually think that particular requirement, while technically an overlay, does have some benefits to demystifying what you all do as a board. Has the potential to even be a best practice because it's socializing your work as a board to potential licensees before they enter the profession. They get a little better idea of what you're about and what goes on in a board meeting, because to your average appraiser, they may not otherwise have that visibility. So that one I'm gonna tuck over in the, hey, that's not a bad idea corner of the ledger. But really, unless Scott, I know you're in the room, if there's any other overlays you wanted to touch on, but that's really the biggest one. And as Pete mentioned, we have the criteria open now. There's an exposure draft out. I would encourage every single state. You all are going to be the ones tasked with applying and enforcing these requirements. You have a vested interest in what this outcome looks like in terms of what the future holds for the profession and licensure. So if you have the time and temerity to go through, review that exposure draft and provide comment on it, I would encourage you all as a board or individually as practitioners really strongly consider not just on the criteria change, but there's concept papers around additional experience, compare profession experience, and super examination as well. And there's also an open comment period on Advisory Opinion 41 that's proposed, dealing with the use of technology and appraisal assignments from the Appraisal Standards Board. So a lot of things happening simultaneously. I always try to encourage engagement with those processes with state boards anytime we have these conversations, and this is a really good time to do so. So that'll pause there, see if there's any questions. Scott, see if I missed anything obvious. But other than that, really appreciate the time you've all made for us today.
Does anybody have any questions for us right now? One of the things I want to point out is one of the major overlays. One of the major overlays is there's 7 states that don't recognize the license credential. And that's really problematic because if you, so the state of Nevada recognizes the license credential. And if you transfer to a state that doesn't have a license credential, then you're out of business because there's no reciprocal license for you.
Most lenders don't take the licensed credential though. So what's the benefit of the licensed credential?
Well, there's 7,700 people doing over 1 million transactions a year.
With just a license.
Mm-hmm. Yeah. And so it would personally be preferable just to have 2 license categories, certified residential and certified general. The problem with that is that takes literally an act of Congress because it's codified in FIREA, and nobody on the Hill has any appetite to open FIREA, so we're kind of stuck with it right now. That's why I would be proposing doing away with it and just either grandfathering those people in as certified residential, but we can't do that.
Yeah.
And so
I would just add too, Pete, and I heard mentioned earlier for our folks who I think are up in Carson City serving more rural areas, part of why you don't see licensed residential appraisers used as frequently is back in 2009, they lost the ability to do FHA related work under HERA, which was a federal act. There's movement in Congress today to remove that prohibition that was placed upon them. So the utility of that license category may actually increase on a go-forward basis. But a lot of folks who had licensed residential tended to be serving less densely populated areas. They tended to be appraisers as well as real estate agents or brokers. They wear 2, 3, 4 different hats in that space because no one stream was providing enough business to be a full-time source of income to provide. But if you could do a few different things that are aligned, that's where the utility came in. So you may actually see if Congress changes back to the pre-2009 environment, you may see an uptick in folks interested in licensed residential. So it's not entirely necessary to ash can it today, but yeah, the utility has been restricted since that 2009 federal law change came into play.
Yeah.
So, good morning, commissioners. For the record, I'm Scott DiBiasio. I'm with the Appraisal Institute, and I'm the Director of Government Affairs out of Washington, D.C. John and Pete mentioned, I think, the most glaring overlay that you all have here in Nevada, which is the excessive experience requirements. But I did want to come before the commission again today and revisit the whole notion of PAREA, the practical applications of real estate appraisal, because that's another area where Nevada is not in harmony with just about all of the other states. Nevada is the only state that has indicated that Perea will not be accepted to satisfy the experience requirements here in the state. And I know a previous commission had very extensive conversations about Perea and decided at that time, after some rules were proposed, the commission decided that you did not feel comfortable moving forward with Perea at that time. However, things have changed pretty significantly. You have 2 new commissioners, and we also now have 2 years of experience under our belt with Perea. And I can tell you that the program is performing phenomenally well. There are about 70 folks that have graduated from licensed residential Perea, which the Appraisal Institute offers. And 40 of those folks have gone on and gotten the LR credential. And I think it's really significant to note that 100% of those 40 or so people that have taken the LR exam have passed on the first attempt. That is not something that is true for folks that go through the supervisor trainee model. I think that the passage rate for trainees taking the LR exam is somewhere around 62 to 67%, which is not really very good at all. So the fact that nobody has failed the exam that has gone through Perea as of yet, I think is indicative that the program is aggressive. It's challenging. In some cases, folks are actually having some difficulty going through the program. It's actually taking them longer than we anticipated to go through the program because it is just that rigorous and challenging. There's another 200 people that are currently enrolled in the LR Perea program. And several months back, we rolled out our CR Perea program. And as folks finish LR, they're now rolling into the CR program. So, and I'm happy to report that many of the folks that have gotten their licenses have been hired by appraisal firms, by lending institutions. And in some cases, a couple of folks have gone on and hung out a shingle on their own and are doing phenomenally well. So the argument that we would be turning folks out of Perea with a dead end road ahead of them with no path to go down to get hired actually is not coming to fruition. So, like I said, the program is performing really, really well. It's no longer a pilot concept. It's an actual program with a proven track record. There are some strong regulatory safeguards that are already built in. We are required to abide by very strict AQB standards. We have to have board-approved sponsors, documented competency benchmarks, and of course, the AQB keeps a constant eye on us and is continuously evaluating our program and suggesting updates. And like I said, these are high-quality training outcomes that address the supervisory bottleneck without, I think, lowering the standards by any means. And like I said, there are positive early results as it relates to workforce development. There's really no evidence at all, really, of consumer harm or degradation of appraisal quality. So all of those point to a program that is really worthwhile, and I think warrants reconsideration by this commission and perhaps the repromulgation of the rules, maybe in a different format, different form, as they were from what they were proposed previously. But now that we have all of this experience under our belt and some of the fears, rightfully so, that the commission had previously, I don't think are bearing out. So wanted to come today and just respectfully request that the board have another conversation about this topic and perhaps consider the adoption of Perea again. Now, I can tell you that there are folks, I know of a couple, that have actually gotten licensed here in Nevada, having completed Perea. And the way that they did that is they got licensed in a surrounding state and then came in by reciprocity. So there are folks practicing now in Nevada that have completed Perea. And I don't mean that as a threat or a criticism, but I do think it's just an indication that maybe the commission needs to just take another look at this And I see no reason why at this point the commission shouldn't, move forward with adopting Perea. So I appreciate the opportunity to come and visit with you all again. It's been a couple of years since I've been here, but it's always a good opportunity. And because of the importance, not just of the work of the State Harmonization Task Force, but the importance of Perea, I thought it would be a good use of time to come and visit with you all in person rather than via Zoom. So I appreciate the opportunity to make a few comments this morning, and would be more than happy to answer any questions, and look forward to hopefully once again working with the commission, with the administrator and the deputy administrator on getting Perea up and running here in Nevada. So I appreciate the opportunity. Thank you.
One of the things that we'd ask you folks to take a look at is when you're looking at these overlays, one of the benchmarks you can especially the increased number of hours to become an appraiser and the increased number of time that you have to be in a training assignment. I would encourage you to ask your provider that provides your national certification exam to take a look and see what your first time test taker pass ratio fail is on that. And if it's significantly above the national average, well, then maybe the time in the seat and the extra hours are working for you. But if your first time test taker pass fail score is at par with what the rest of the nation is, which is for certified general, it's 55%. Certified residential, it's 62, and then licensed, it's like 65 to 66. And so if these candidates are spending an extra 1,000 hours doing appraisal work and an extra 6 months to a year for the requirement to get licensed in Nevada, and your first time test taker score is not any higher, then really what's the point of having the additional hours and the additional experience if it didn't bear out that they did better on the exam? So that's one of the benchmarks you could look at. And all you have to do is have your staff ask, do you guys have PSI? Is that who does your exams? Oh, okay. Just ask them what your first time test taker scores were. We can't, even though it's our exam, we can't get that information on a state by state basis. We can get it on a national basis, but just ask them what that first time test taker score is for each of those. They have to keep track of that for the foundation. And then use that as one of your benchmarks to say, are these overlays us helping better prepare these people for candidacy? And if they're not, then take a hard look at them and say, maybe there's no reason to have this type of an overlay. And especially with the new criteria coming, you're going to have to take a look at the new criteria and codify that either into your rule or statute when that becomes final in the next probably 12 to 18 months. And with that, I mean, folks, that's all we have. We're here as a resource for you. We're always available at the foundation. Our task force is not going away. We're going to visit all 50 states. We're going to try to help boards and commissions through the process of amending their rules to be more consistent across state lines. And we're here as a resource, and that's it. Like I said, we have no regulatory authority. We don't have any authority over your board, but we're here to let you know that we're available anytime.
One thing that's kind of interesting, and I just thought about this when Pete was talking, is that many of the commissions and boards that we visited with aren't even aware that they have these overlays. And when we identified the overlays for them, it's really an eye-opening experience. Now, I'm sure you all are aware of the experience overlays that you have here in Nevada, but we visited with one state in Indiana where we identified something and they were like, really? And then they committed to at least considering changing the regulations based upon that. So there may be things in your regulations. Now, I know your commissioners have a very strong understanding of the regulations and the statutes. Mr. Kruger's citing of the law there earlier this morning in one of the cases, I think was indicative of the fact that you guys really do understand your laws and regulations very well and probably know them, verbatim. But there are a lot of commissioners and board members in other states that don't really understand what's in their regulations and what the practical impact is of those excessive overlays. So I just wanted to add that.
Is there any questions from anybody online or in the room?
If this is Commissioner O'Brien up in Carson City, I've just got a couple of questions. One of the challenges that we've seen over the last year to 2 years in discussing this with parties in the industry is lender adoption. So I'd like to understand where you are with lender adoption, because all these programs, and especially mass appraisal, which I'm very interested in using that as ours. The person gets done, they get their license, and then a bank says, well, it's 2 years of experience you got to get on your own, then you can apply to do work for us. And, even with Jerry Urich, when he came about 18 months ago, he had a nice presentation, very professional. And then I asked him, would your bank be willing to hire one of these people either as an independent contractor and or employee? And his response was, no, our bank would require 2 years of experience. So what lender engagement has happened and who signed off? I like to hear the back end part of it before we get into any other questions.
Mr. President, I can address that from the PREA perspective, which is what we have found is that many of the folks that graduate from LR PREA and get their LR credential are actually going to work in appraisal firms, continuing to work under certified appraisers to continue their training. And I think that's the way really that they are going to get the experience or getting the experience that they would need to go into a lending environment. Now they're licensed appraisers. They're doing quote unquote live appraisal work, but they're doing so under the tutelage of a certified appraiser or certified general, and continuing to get their training and to hone their skills in that capacity. Many of the folks that have become licensed, many of the 40 have gone about it that way. From everything that we understand and are being told, they are, thriving and really producing some quality appraisal work. And I would add a board member in another state, and this is a little bit off topic, but they have a requirement that trainees submit work product for experience review. I don't know if you have that requirement here in Nevada or not, but in many states, trainees are required to submit usually 3 appraisal reports for review for compliance with USPAP and standards, other standards and regulations. And this board member in another state indicated to us that the 3 reports that had been submitted to his board by somebody that had completed PREA were by far the best appraisal reports that board had ever seen. So I think that's just another indication that folks that are coming out of PREA are well-trained and are producing some really high-quality appraisal work, albeit in a virtual environment using simulations and such. But I don't think that really degrades from the fact that these folks are coming out well-trained and well prepared to go to work in whatever capacity they go to work.
And I would just add too that, it's the same challenge that we've had historically with the use of trainees in lending related assignments for mortgage lending, is there was miscomprehension or apprehension around, if I use a trainee, will I have a problem downstream either with the lender or with the GSE? So a lot of what drives that decision tree comes down to the risk understanding and sometimes misunderstanding of the underlying institution. And I know on the industry side, we have relationships with ABA and MBA and others who are talking with their membership on a regular basis. It's not a lack of effort to better educate around the capacity of somebody day one post licensure to go out and do work that's just as credible and substantive as somebody who's been doing it 2 years. But it does take time to create that comfort level because you have to go through a series of examinations at the, if you're talking about a depository institution where they pass and they don't have issues using that individual maybe with less experience before they really settle in and go, okay, this isn't going to create undue risk for me as an institution. Ultimately, that's what they're trying to avoid. And on the non-bank side, it's simply, is this something that Fannie or Freddie could potentially push back on us for repurchase if they feel uncomfortable with something that's happened here, in spite of all the fairly robust QC tools that exist in that flow. So it takes time. It's getting better than it was. I think we're seeing improvement on trainees, certainly. I think we're seeing more improvement away from, well, you have to have 2 years of experience. Well, how do I get the 2 years of experience if you won't let me do the work and get experience, right? Very chicken egg problem. But that's something that's an ongoing conversation. I know that a lot of the engagement that we can drive from the foundation side, putting that hat on, is with the Industry Advisory Council that meets on a three times annual basis. And talks about the industry facing issues for lending in other corners. And so that's something that we can certainly surface as a continued pain point and concern, and hope to continue to move things in a positive direction.
Sorry, I was on mute there. I appreciate everybody giving the additional detail, but I want to step back. Are there any lenders working on the harmonization task force?
What was that, Mr. President?
Are there any lenders? Are there any lenders currently working on the task force with you guys?
So our task force, with our industry advisory council, we interact with them, and I'm a representative of the board of trustees on the industry advisory council, which is chock full of lenders. And so we pass this stuff through them all the time because we want to make sure that we're not going down the wrong road. In addition to that, one of the things that the states always bring up is that what's the appraisal subcommittee going to think about this stuff? And so one of our task force members is also one of the program managers for the appraisal subcommittee. So to make sure that when we're making suggestions to state boards, that they're in sync and lockstep with the subcommittee. So we don't have, and I can email you our new task force for 2026. There's 4 state regulatory board members on that are trustees, and all of them are chairs of their boards. And then it's made up of industry advisory experts. And so, but that's a great suggestion. And in fact, I'll run that by our current chair, Frank Gregoire, and ask him if we can put somebody from the ABA or the MBA on our task force.
Yeah, I mean, I think it would be helpful. Am I good? You can hear me. Sorry. Yeah, I think it would be helpful. I mean, I know I'm in my 6th year at the commission, and we've heard a lot of different things, but I haven't seen a big box lender or a medium-sized lender, what have you, come and say, we stand behind this and we're going to waive our 2-year requirement after the person gets licensed. And that to me is just protecting those folks that may come in through this process. That it's not a surprise at the end to say, hey, I got all my work done, but nobody will hire me for another 2 years. It's kind of just a circular process. And that's what I'd love to see, is if there are lending institutions that are making change in lockstep with this. Because I think this is a very good presentation. I read over Mass Appraisal the other day and went through there, and I think it's a great way to address some of the issues. But again, if there is a lender that says, well, you can't use Mass Appraisal, or you what have you, I think that strengthens your case if the end user of the product or service is there and willing to make change.
I will tell you that Fannie and Freddie are big supporters of our task force and participate in most of our monthly meetings as well. And we have a representative on our task force that's representing REVA, which is one of our partners at the foundation, which, as you know, Mr. President, represents most of the large appraisal management companies that direct engage with banks and lending institutions. And so our new member of our task force is Dan Figursky, and he's the chair of the Wisconsin board, as well as the chief appraiser for single source AMC is. So he's one of our task force members as well. But I hear what you're saying, and I will definitely talk to the chair about that.
Yeah, and I would just observe too, the charge of the AQB in promulgating the criteria, and ultimately your responsibility as a board in upholding it and enforcing it is, we're trying to create minimally qualified individuals who are capable of obtaining a license. I put it in the analog to, I look up on my wall in front of me, that's my law degree. Just because I graduated law school, the next day I'm not trying a capital murder trial, right? And I think sometimes lenders fall into the trap because of expediency, that they will just check every possible overlay box or requirement box, so they don't have to go out and redisclose or hire a different professional or whatever the case may be. It's not an efficient practice necessarily, and more to the point, it doesn't recognize the fact that somebody who holds a license from your state or any other state is minimally qualified. It's up to that appraiser to demonstrate competence to take on that assignment, and ultimately to be able to discharge that responsibility in a credible fashion. And that's an underlying, I don't want to say tension in a negative way, but that is one of the underlying challenges we're trying to solve for, is aligning what it is that the AQB has said makes one minimally qualified versus perhaps what market demands are in terms of experiential or other requirements. And that's always going to be dynamic over time. That doesn't really sit in one place permanently. But again, I think to Pete's point, we have folks coming in from the AMC perspective onto the task force, and we have continued dialogue with the Industry Advisory Council. And as long as those two things are still happening, hopefully we can continue to win over more hearts and minds and get people more open-minded generally to their hiring practice, similar again to what we saw with trainee appraisers over a period of years as well.
Sorry, I'm using this new mute button. It's not working. Great. Thank you for that background. I do have one other just kind of comment or question. When you look at our state here, and we're kind of original in terms of it. I mean, I consider us a lot more Pete state than I do California, Texas, Oklahoma, what have you. The majority of our state is very rural, and there are two major cities. There's Vegas and Vegas. And I say that a little tongue in cheek because, I mean, the majority of our population is down in Vegas. And then Reno, obviously, being, the second area where we need as appraisers or as appraisers from the commission or lenders or what have you, is the folks to fill in a lot of the blanks, where people don't go. And the struggle with that is people don't want to live in these spots because there might be 3 appraisals in a month at most. So I like the idea of the mass appraisal, especially in that situation. And I know you guys haven't been all through our state, but many assessors are right outside the one stoplight town, and they're using hard cards still. It's a very difficult process to work with some of the less funded or less, I don't know how to say it nicely, electronically developed, but I can't even mute a phone. So I guess I'm in that bunch now. So that would be another thing is just, how you look at things, especially with mass appraisal and other options to say, look, we don't need appraisers in Vegas right now. And if you want to live in Vegas and be an appraiser, it's going to be really hard for you to break in. Reno, it's a little bit easier, but you're working on still a wide swath of territories. And then once you leave Reno, it's one corner up to Elko, and that's all in between where they're towns of 10, 20, 150 people. And it's just one of those things. That's where our help is needed the most, of how to get folks that want to work through those assignments. So again, not a question per se, but maybe just something to take back, especially in rural states that really struggle with getting people in the rural areas, opposed to I want to work in Vegas.
So, and Mr. President, you know well from our past history, you and I, that I live in Montana and we suffer those same struggles. Yep. And it's the one attractive thing about the mass appraisal experience and these folks. There's an assessment individual in almost every single county across all 50 states with experience in those areas. And your point's well taken. That there's more interest in rural states in getting people licensed and certified than there is in general population centers. And so I presented to our legislature 2 terms ago, and of the 56 counties in Montana, 28 of those don't have a licensed or certified appraiser in them, but every one of them have an assessor. And so your point's well taken, that the rural states suffer a different dynamic. The VA has 200 and some unassigned cases in Alaska that they can't assign. And so they're going to have to get valuations somehow for those veterans. And so they're doing it with desktop appraisals from the lending center, the transaction center. Northeast Maine is a problem. Southern Colorado, Montana, Wyoming, North Dakota, South Dakota. And if you remember, North Dakota asked for a waiver of appraisal requirements back 4 years ago or 5 years ago.
It's been a while.
They asked the appraisal subcommittee for a waiver because they were so short on appraisers in those rural areas. So your point's well taken, and we are cognizant of that.
And I would add too, I work a lot with the city of Philadelphia on appraisal issues. And ironically, they have the challenge of plenty of appraisers willing to do work in Philadelphia, but nobody wants to live there. And so the same mentality we've started establishing in Philadelphia, in a funny way, carries over to the rural areas. It's not just an appraisal issue, right? It's a banking issue. It's a finance issue. It's a workforce development issue. This is one of those challenges where I always encourage, don't just view it as an appraisal problem and then try to solve it that way. This may be a great conversation for your Department of Banking and Finance. It may be a great conversation for your statewide workforce development folks to pull them in and say, hey, we still have people who want to live in these places, work in these places. How can we create an ecosystem that supports the appraisal professionals who are going to be necessary to help them get that mortgage, help them get that loan to be where they want to be and do the work that they want to be doing, supporting the economy of Nevada as a whole, and not just your largest population centers. It sounds like a big lift. It certainly can be and takes time, but I think when we stop just viewing that particular challenge as an appraisal problem, it's a broader finance and banking problem, you can get more people to the table with an interest in trying to solve for it and then come up with some pretty innovative solutions. So that might be one direction I'd encourage you all to go, is going and talking with your peers who are going to have those same demands and needs that need to be met and say, hey, what can we do to get people out there doing the work on a regular basis? Because we know it's not day to day, right? It's potentially week to week and sometimes month to month. But when you start pulling the right people to the table, you'll find the solutions are a little easier to come by.
Okay, great. Thank you. Other commissioners, questions? If the commissioners have not read the part on mass appraisal, I encourage you to do it. So very well put together. It may be something we have to look at down the road, but I do think mass appraisal has some level of applicability in the licensing and pre-licensing areas. So like I said, commissioners, if you have not looked at it yet, it's a good read. So anyone else have questions in Vegas?
No, sir.
Anyone else in Carson City?
Nope.
Well, I think we should pull virtual either way, just because this wasn't in closed session. So it was open to public. Any virtual comments?
I'm not recognizing anybody who is interested in making a virtual comment.
Perfect. All right. Well, I thank everybody. I thank you guys for coming down to Vegas. Make sure and leave a little money, hit the casinos, state could use it. And appreciate the time and the effort that you put forward to this. So hopefully we can. Oh, go ahead.
I just want to, on behalf of the Appraisal Foundation, I want to thank the Nevada Commission and the staff for accommodating us. And we appreciate the opportunity to be here. And if you have any questions in the future, just reach out to us. We're happy to come back. This isn't a one and done for us. We're here as a resource. And so we've made a commitment at the foundation to be available to you folks.
Perfect.
Thank you, commissioners.
Thank you.
Thank you.
Thank you all.
Thank you.
All right. We just have a few items left, so I think we can go through them. We are on point 6, commission division business. And this first section is discussion regarding the administrator's report.
Good morning, commissioners. President Sharad Chandra, administrator for the real estate division. Just as an update, we are already beginning the process for the next biennium. So we're working on budgets. We're working on a staffing plan. We are working, I believe this session, we are also looking to do one more attempt at self-funding. I believe this may come through the governor's office as a GovRec budget. So looking at the real estate community, and hopefully we are able to pull it off this time. So it allows the division a little more fiscal ability to increase services and things like that. And I think it also will help the appraisal program too. With us going self-funded, we were able to resource allocate a little better. So that's a big one. I think really like where the appraisal staffing is right now. We've got James, we've got Barry now, and Rebecca overseeing it. I believe Barry has already started working on a newsletter. So I think there's some good things in the pipeline coming through. Our goal, I believe, for the next legislative session is to look for a larger bill, because we are working on HOA issues, 116, and also a couple of tweaks. And with the self-funding bill, there's an opportunity to make some changes. And so some kind of an omnibus bill that includes changes to 645, 645C, potentially 116 is something we're looking at. And then commissioners know business and industry, which is the larger department, they do not get a lot of BDRs, which are bill draft requests. So agencies have to be kind of picky on what we decide to use those BDRs for. But we also have an opportunity now because of the new director to allow us to work with lawmakers to probably sponsor a bill or look at avenues to add to existing bills. So we're kind of contemplating some ways to bring legislative changes that we want to do. So we'll keep the commission up to speed on where we're going. But really for us, the big thing is to look for opportunities to opening a licensing office up north, which has always been one of our stated goals. We are also looking at maybe merging some of the education sections because we've got the HOA education, we've got appraisal education, we've got real estate education. So this might be an opportunity to kind of bring it all into one structure. Maybe that uniformity will help how we process applications, how we approve education. And of course, we have the technology project that we're working on. So between those few things, we're hoping to streamline a lot of these activities. And of course, licensing. Licensing will be another area that we're focused on. I think we've always wanted to have some kind of an online presence, but this one, our goal is to move almost everything online and avoid as much as possible, the need for people to come into the office unless you want to come in for something specific. Most of the activities should be done online. And so that's been the goal. I believe we're working towards it. The technology project, I want to say about 50% into the project. We have a consultant on board who's helping guide the licensing, the new licensing software. Just with anything else, we're going through some kind of growing pains, but I think we'll get to the end of this. I want to say by end of 2026, we should have at least some licensing features rolled out and then some educational features come along with it. So that's the larger update. Nothing really changes for appraisal per se, but if there are any changes to, there's no fee increases, there's nothing contemplated as far as changes. We have the technology fee already established, so I don't believe there are any increases in fees. We're just trying to figure out a way to provide more resources, more services within the existing fiscal structure. It's just realigning how the general fund treats us and moving more money to the division so that we can better resource allocate. That's all I have. I'm happy to answer any questions or any comments, concerns. Happy to take any questions. Thank you.
Thank you. All right, no questions?
I don't have any questions. One quick comment, which you probably hear from me pretty regularly. If the governor does not appoint someone, at least one person to this commission in the next 6 months or so, it won't be compliant with state law. There will be no quorum. So I know we all got to get to work out there and try to find replacements. Maybe somebody from the audience back there might want to consider throwing their hat. If you do nothing.
Yeah,
I mean, I would say that one of our challenges is probably fixed to some level with Mr. Morris having a commercial license and being one of outstate areas. So we kind of tick two boxes with that. One, we need to have two commercial members, check. And then as he lives out in Elko, right, Elko?
Yep.
Yeah. He lives in Elko. We're outside the normal, Clark, Washoe areas as well too. So I'm happy that that's happening. And we do need another commercial appraiser at some point, but I think you can go fishing in Vegas for that and probably find it better than the outstate areas.
Yeah, and I think Commissioner O'Brien, again, this is another, because the way the statute reads as far as the composition of the commission, that's an interesting area too. So if we can relook at that, the composition also, if it makes sense, does it still make sense, or that composition change? This was kind of the things that I was saying, is there might be an opportunity in legislative session to, the division might pull in a omnibus bill that kind of pulls in a lot of different statutory areas that we have jurisdiction over. So we could use that opportunity to make some changes. So for commissioners, just think about these things and let us know. But yes, I think to Commissioner Kruger's point, I believe Commissioner O'Brien and Commissioner Kruger are coming up soon. I think you've already served 6 years, so you're termed out, and we still have one vacancy left. So we still need to beef up the commission. And we go through this, and we went through this, I believe, 3-4 years ago when we completely emptied out the commission, and there was, the new administration came in and there was a huge gap of even appointments. We had a lot of requests into the governor's office, and it took a while to get everything situated. And we had a great 4 or 5 years now with a full commission, and now we're back in that cycle again. And I think the biggest challenge has been trying to get someone to volunteer to serve. I think we got lucky last couple of years, but we'll reach out, and please, send us names if you have any, and we'll go from there. But hopefully we'll get someone in. I know we have a good relationship with the governor's office, so the timing of appointments can be expedited. I think we just need folks to apply and let us know, and then we can kind of coordinate all of that stuff. Thank you.
Perfect.
Thank you.
All right, seeing no more questions, we'll move on to point B, discussion regarding the disciplinary report.
Good morning, everyone. My name is Shrew Spates. I'm the administration section manager for the real estate division. Commissioners, in your packet, you have the most updated, well, it's updated as of December 31st of the disciplinary report. Pretty standard. Just as a reminder, any changes since the last commission meeting are highlighted in yellow, and anyone who has completed their disciplinary as ordered will be grayed out. So we do have few people who have completed all of their order discipline, but otherwise we look good in terms of pretty regular payments being made from those who have been ordered. So that's a good thing. Please let me know if you have any questions.
No questions. It's just I need 3 pairs of glasses to read it. I say the joke every time.
Yes.
Honestly, I'd have my kids read these. Maybe it's like a little label on them. All right. No questions?
Thank you.
No.
All right, let's move on. Point C, discussion regarding chief compliance investigator report on compliance caseload.
Good morning, Commission. Rebecca for the division. The appraisal report are numbers through December 31st, 2025. So basically the end of, or the first half of the fiscal year of 2026. If you have any questions, please let me know. We do have quite a few new things going on. I know with our last meeting that was canceled, I wasn't able to update you on some of the things that have been going on within the compliance section. The biggest one being that we did complete our review, our ASC review. We did get the results back from the AMC program review, and that was a result of good, or a rating of good. We are still waiting on the appraiser program results. The ASC did have some turnover recently, so they're just kind of waiting on that report or that review to be approved and finalized. Once they do that, they will get that back to us and we'll let you guys know those results. But overall, the results or the review went very smoothly. I'm optimistic about our results. I think we've had a big improvement over our previous results just in what I've seen myself. So I am optimistic about that. We did also expand the appraisal program or the appraisal section. We've hired a new appraisal program officer too, which is Barry. With my transition over to also overseeing the real estate compliance, it kind of was a lot to take on. So Barry is kind of helping a lot with the education side of things and kind of keeping the appraisal program going while I kind of focus on the compliance side of it. So he's pretty much my right-hand man along with James. So again, welcome Barry. He has been working on bringing a newsletter back. It's been 5 years since we've published a newsletter, and I'm happy to say that the first edition in 5 years is now officially published and on the website. So please make sure you take a look at that. It's updates on what's going on in the industry, updates on what's going on in the division, and also it's going to include stuff about our inspector program as well, because it's sort of a combined section. So there'll be opportunities to be guest writers or guest speakers in the newsletter. And so if you have questions or if you have ideas for topics for the newsletter, reach out to Barry. Other than that, the new discipline matrix that I discussed in our last meeting that we had, it's actually, we've now had 2 successful conditional dismissals. That was our new kind of disciplinary step that we've added in there. And from the one that we did successfully complete, the feedback was actually promising. He was actually very pleased with the process and felt that it was beneficial and would help us streamline our processes going forward. So any other questions about anything? No?
The only question I would have is, can you circulate Barry's email?
Yes, I will circulate that to you guys, but it is also on the newsletter. If you check out the newsletter, it does have that contact information on there.
Do you announce that the newsletter's out there, or you just assume people are going to go look at the website?
We do have a listserv email that we can send out to all of the registered email addresses to let them know. We have not done that yet. Again, this is kind of a new process, learning process for Barry and I, since it's been 5 years since it's been published. So that is a very good suggestion, and we will take that on board.
Obviously, the other benefit of using the listserv is if you get 100 emails back saying they're not valid anymore, we have a lot of appraisers who have not updated their info.
Yeah.
All right, great. Appreciate the update. All right, last item in section 6 is the for possible action discussion, possible action to approve the minutes of the July 22nd to 2025 meeting. Commissioners, any questions you may have? Otherwise, I'm willing to hear a motion for approval.
No questions.
Nope. President O'Brien, I've read and reviewed the minutes and I move to approve.
I'll second the motion.
Right, any other comments? So approved. Thank you. Number 7 for possible action, discussion and decision on date, time, place, and agenda items for upcoming meetings.
Good afternoon, Sharice Bates again, Administration Section Manager. The next meeting is scheduled for April 21st through the 23rd. The commissioners, we will hope to see everyone in Las Vegas. Travel and logistics pending, but April 21st to the 23rd is our scheduled date.
Great. Any other topics for that agenda item? Hearing none, move to section 8, which is our public comment period. Members of the public are encouraged to address the commission regarding any matter. However, no action may be taken on a matter. No comments may be made regarding a matter that is or may be the subject of a formal complaint before the commission. Comment may not be limited based on viewpoint. Persons who desire to submit written testimony should submit it to the commission coordinator. Anyone participating over the phone that wishes to provide public comment should press *5 on your phone to raise your hand, and hosting staff will recognize you that you would like to give public comment. Or you can press *6 to unmute yourself and state your name. If you're attending by video, click on the raise hand emoji to indicate that you would like to give public comment, and hosting staff will recognize you, or you can unmute yourself and state your name. Public comment may be limited to 3 minutes per person at the discretion of the president. So we have no one here in Carson City. I'll ask Vegas if there's anyone wishing to provide public comment.
Doesn't
Not
look
hearing. Okay, virtually.
There's no one raising their hand to give public comment at this time.
Perfect. All right, so then we have covered the agenda fully. I move that we adjourn and thank everybody for their time.
Here.
Yeah,